Hello, and welcome to the GRadulting Workshop Series. This is brought to you by Graduate Student Legal Aid. My name is Debbie McCutsky, and I'm the Coordinator of Services and Programs for Graduate Student Legal Aid. Our focus today is an update on the latest developments in U.S. immigration policies. We are in an ever-changing world right now, and I hope that the information you received today is helpful as you make plans for what's next. So before we start the presentation, I want to tell you a little bit about legal aid in case we didn't get to meet you at orientation. So what does legal aid do? In addition to workshops like this one we're having today, we provide legal consultations for local issues. We provide legal consultation for immigration issues. Those are done twice a month. And our next 2 days for those consultations are December 17th. Oh, and before that, December 10th. I will share the link for that in a bit in the chat. So if your visa is sponsored by the University of Maryland, you should first contact ISSS with your questions. Don't come directly to us. First, go to ISSS. If they cannot help you, they will suggest that you come to legal aid. And I am happy to say we have a representative from ISSS with us today. Her name is Jody Heckman-Bose. Some of you may know her. She is the Associate Director for Student Services and has been a good friend to legal aid over the years. So welcome, Jody. Thank you for being with us today. All right, so what else does legal aid do? We provide advocacy for students who are facing university charges or have Title IX cases. And finally, notary services. I'm a notary public, and I'm the person that will be helping you with that. So you'll want to know, does this cost anything? Well, you've already paid for these services because you've paid your student fee. So get your money's worth and reach out when you need help. I encourage you to visit our website so you can learn more about our services. You'll find lots of information and links for requesting an appointment. So just a few more rules of engagement. So this session is being recorded, and tomorrow I will share a link to the recording, the slides, and any other resources by email tomorrow. You can also always look for resources on our website. Today we're using the Q&A feature rather than the chat for your questions. So you could use the chat if you want to contact me. Otherwise, if you have a question for the speaker, please use the Q&A. That helps us keep track of all the questions that may come in. And don't be shy about asking questions. We're all here to learn and grow together. So finally, we are at the time where I get to introduce our speaker, and it is a great pleasure to welcome back attorney Patricia Minikon. Welcome, Patricia.
Thanks, Debbie.
She is the founder and owner of Minikon Law, LLC, which is a local firm. Patricia has been practicing immigration law for over 30 years, so she has a deep knowledge of even this very dynamic immigration system we are now living with. And she has been working with legal aid here at the University of Maryland for 10 years as a volunteer and as a contractor. So our office contracts with her to meet with our students twice a month. And as I said earlier, the next 2 dates are December 10th and December 17th. And we will soon be posting the dates for 2026. So without further ado, I'm going to turn this over to Attorney Minikon. Take it away.
Okay, thank you, Debbie. It's a pleasure to be back with the student body, and The goal of the presentation today is to talk about pathways to immigrate in the US and some of the changes that are impacting those pathways and the various processes. Toward the end, I will talk about specific policy changes that are outside the legal pathways, and then there will be a discussion of policy changes that affect students specifically. So there are four primary ways to immigrate to the United States. Um, One is through humanitarian programs like asylum, U visa, which is for victims of crime, T visas, victims of trafficking, VAWA, which is for it's the Violence Against Women's Act, but it protects men and women alike. And it is for persons who have been abused by a US citizen or permanent resident, spouse, or parent. And then you have the SIJS, which is Special Immigrant Juvenile Status. And that program is specifically for persons under 21 years old who come to the US without their parents. They're called unaccompanied minors. The next pathway is through family sponsorship, where a relative sponsors a person, which the qualifying relatives who can sponsor are spouses, um, children who are 21 years old, parents, and brothers or sisters. Then you have employer sponsorship, which would be the employment-based visas for persons who either require 2 years of experience for the position or have a bachelor's, master's, or PhD. And then we have self-sponsorship. This category is where you can just sponsor yourself. You do not need an employer. You do not need a job offer, even though you could have a job offer or have an employer. And then we have the investment, which again is self-sponsorship because you do not need a job offer or an employer. You would have to meet investment thresholds, and I'll get into that later during the presentation. So for asylum, one policy change is that now there's an annual fee after an application has been pending for 365 days. What this means is that on average, the wait time is 10 years for an interview. So applicants will be paying this fee until they're scheduled for an interview. The requirements to obtain asylum are that you apply within 1 year of entry, you apply, or you apply within 1 year of changed circumstances that lead you to need to file for protection. Asylum is granted based on the person's fear of persecution because of their religion, their particular social group, their race, their political opinion, or their nationality. If granted asylum, you can apply within after a year. However, you cannot return to your home country until you become a US citizen. Even though you can apply after a year, USCIS policy is that you can apply right away after being granted because processing times for applications are over a year, and by the time they actually get to your application to make a decision, you would have been an asylee for more than a year. You can have other applications pending simultaneously. The beautiful thing about the United States immigration policy is that until you actually get a green card, you can pursue various avenues to obtaining that permanent status in the US. A second humanitarian program, which I referred to earlier, is a T visa. It's a temporary non-immigrant visa that's granted for 4 years, but you can apply for adjustment of status after 3 years or after the trafficking case is closed. You have to be a victim or of sex or labor trafficking. Sex trafficking is where someone is forced to engage in commercial sex act, um, but they have been induced to do this by force, by fraud or coercion, or that the person is a minor. Labor trafficking is where you are duped into providing labor or services, and you're made to do this through force, fraud, or coercion. And it's for the purpose of involuntary servitude, peonage, debt bondage, or slavery. So what this means is if you respond to a job advertisement saying you will make, you know, $500 a week, for example, and once you start working, you actually are making something that's less than the minimum wage in the United States, that can be labor trafficking. You do need to assist law enforcement in its investigation or the prosecution. So you either would be the one reporting this or law enforcement would be involved, but you do need to be willing to say testify in court. And that's what is considered assisting and cooperating with law enforcement. Again, you can apply to become a permanent resident after 3 years. The U visa is for victims of specified criminal activity. Some of these crimes would be a felonious assault, where a weapon is used to maybe rob you or just to threaten you, where you're put in fear of being harmed. Crimes against the person, rape, murder, domestic violence, blackmail, stalking, witness tampering, and related crimes. So there is a list that usually, if someone wants to determine whether they qualify, we check the crime against the list. However, two things are important. The list says other similar crime. And so if someone is robbed or involved in a theft that is being perpetuated with a gun, then we would put that under the felonious assault because theft isn't one of the specified criminal activities. So it's important to know that the crime a person is a victim of does not have to be specifically listed if it includes elements of the listed crime. So for example, someone who is made or locked into a room after they're robbed, you could use the fact that they were locked in that room to qualify them for another crime, as opposed to simply the theft crime. The person must have suffered mental or physical harm. So either the crime resulted in a physical harm, like say a domestic violence offense, and or the person needs to have suffered mental harm, meaning if the person is robbed at gunpoint, they're probably going to suffer from anxiety as a result of that close encounter with death. So you want to look for both. You have to be helpful in the investigation, and actually it is required that law enforcement certify that you assisted. There's a form that they need to sign, and then you submit that with the application. The crime has to have occurred in the United States. And again, the person is given a temporary visa for 4 years, and they can adjust their status to a lawful permanent resident status after 3 years. VAWA, this is the Violence Against Women's Act protection. And the person has to be a victim of battery or extreme cruelty committed by a US citizen or permanent resident spouse, former spouse, parent, or child. You're given about 2 years after you get a divorce to continue to apply or qualify to apply for the Violence Against Women Act. You apply to adjust status when either the VAWA petition is approved, or if the spouse is a US citizen, or even if the spouse is a permanent resident, but your visa availability is current, then you can apply to adjust your status right away. This is one relief that is available if you're in removal proceedings as well. And it's at that point, it is called a 3-year cancellation of removal. It's a little different from the VAWA that you file affirmatively, in that you need to be a resident of the US for 3 years, whereas with the VAWA that you file with USCIS, there's no time required that you have to have been in the US. So for these humanitarian programs, for some people, even though they may have another means to adjust status, the humanitarian programs might be more advantageous. So say someone who came into the US without a visa, for example, may have a US citizen spouse, but they would not be able to adjust status. And therefore, if they qualify for one of the humanitarian programs, they could adjust their status through that program, because there's a waiver for persons who enter the US without inspection, or who have fallen out of status, who have convictions, etc. So these would normally be bars to adjusting status through other means, but not if you're adjusting through a humanitarian program. It's also very helpful for persons who are undocumented or documented but came in without a visa. So that's good to keep in mind. And these programs continue despite the changes to immigration law that have occurred. The Special Immigrant Juvenile program is for minors who are less than 21 years old. They must have suffered past abuse, neglect, or abandonment by their parents. Abuse would be physical discipline, hitting the child. Neglect would be non-support of the child. And abandonment could be where the parent just leaves the country and the child has to live with relatives, and they no longer have contact with that parent. Or abandonment could be by one parent who leaves the household, thereby rendering the other parent a single parent. That also qualifies as abandonment. Now, abuse, neglect, and abandonment is determined by state law, because to get the order finding the past abuse, neglect, or abandonment, you file in state court, and a state judge determines under state law what constitutes abuse, neglect, or abandonment, and whether the minor meets those requirements. You can file for adjustment of status once you're granted the special immigrant juvenile status. There's a wait, so you just have to check. The longest the wait has been is 3 years. But again, like I said, you would just check. There's been a policy change, and before, given the wait, like I said, it used to be a 3-year wait, and there's still a wait now, but it fluctuates. Given the wait, USCIS would grant deferred action after the special immigrant juvenile petition was approved. And with that deferred action determination, the minor could apply for an EAD while waiting for a visa to become available. That has changed. No longer, juveniles are no longer able to obtain an EAD, and they have to just wait until their visa becomes available. This again is a good path for an undocumented or documented person, because if they are under 21 and there's enough time before they turn 21 to obtain a court order, they can use this as a pathway to getting a green card because, again, it waives entry without a visa. So, and um, other things, other eligibility factors that would pose a challenge for getting a green card through, say, marriage or through an employer. Um, Now we turn to family sponsorship. And with family sponsorship, there are different categories. They're called preference categories. The first category, which is not a preference because there are no visas available. I'm sorry, there is no bank of limited visas made available for each fiscal year. So immediate relatives always have access to a visa and they never need to wait. This would be spouse of a US citizen, parent of a US citizen who's 21 years old, and a child who is under 21 years old and being sponsored by a US citizen parent. Um, while there is no penalty if you have lost your status or you're out of status, have overstayed your visa, for example. However, it is required that you make a legal entry. So, meaning you need to have come in with a visa or some sort of legal permission. Um, and if you are the spouse of a US citizen or the parent of a US citizen or child under 21 of a US citizen, there is no penalty if you apply to adjust your status within 90 days of entering the US. Usually, for other categories, um, if you enter the US and try to adjust status within 90 days of that entry, you are deemed to have held immigrant intent when you entered. And that goes back to your visa interview at the embassy and whether you misrepresented the true reason for coming to the US. And this can bar you from getting a green card because it is a ground of inadmissibility to misrepresent information to an immigration officer. The preference categories, people who need to wait for a visa, are the adult children of US citizens who are over 21 years old, spouses and unmarried children under 21 of permanent residents, unmarried children of lawful permanent residents who are over 21 years old, brothers and sisters of US citizens, and married children of US citizens. The process is that the petitioner files the relative petition, um, which is the Form I-130. And then the person, the beneficiary who will be getting the visa, is scheduled for biometrics collection, which is taking fingerprints, running a background check. And then you're scheduled for an interview. And if your visa is available, if you fall into one of the preference categories, if a visa is available, then you're able to adjust your status. The forms that are normally required would be the relative petition, the I-130, the I-485, which is to adjust your status, the I-864, which is the affidavit of support, which is a contract between the sponsor or petitioner and the US government. And then if you want to work, you would file the EAD application or work permit. And if you want to travel, you would file the petition for advanced parole. If someone has an adjustment of status application pending, they cannot travel without first obtaining advanced parole, which is permission to travel. If you travel without that permission, your application for adjustment of status is automatically denied. So it's very important to obtain it. You do need to provide supporting evidence. If it's a marriage-based case, you need to provide evidence that it's a bona fide marriage, that you're commingling assets and liabilities. If it's a parent-child or child-parent petition, you do need to provide proof that you are either the birth biological or adopted child, or the relationship is one of adoption or biological. And for persons who were born out of wedlock, if they're petitioning for their father or their father is petitioning for them, they need to show they had a relationship prior to the age of 18. So these are things to keep in mind. Now, there's no requirement to live together before the marriage, but you do need proof of your intention to have a shared life together after marriage. So for some people, if they do not live together before marriage, they may need about 3 months or so after they start living together to be able to provide the kind of proof that they're sharing a life together. Now, the policy change before USCIS waived interviews if the supporting documentation strongly demonstrated the relationship and a shared life together for marriage based petitions. Now, all applicants are interviewed, and that has been a major policy change where everyone needs to attend an interview now. So, as I mentioned, the sponsor does need to include the affidavit of support. And the beneficiary, if the marriage is less than 2 years old, obtains conditional lawful permanent status. And that means they get a green card for 2 years, and 90 days before the green card expires, the parties must file a joint petition to remove the conditions. And if it's not possible to file a joint petition, the person who has the conditional status can apply to waive that if they have, if they've been abused, if the marriage ended through no fault of theirs, or if they've lost their spouse due to death. Divorce does not remove the obligations under the affidavit of support that the petitioner files. So it is important to keep that in mind, that it's, the affidavit of support requirement to support the spouse until either for 10 years, until they've acquired 40 Social Security quarters, or until they become a US citizen, would survive a divorce. And divorce does affect the conditional lawful permanent resident because you are required to file that joint petition, and there are only certain reasons you can get a waiver of the requirement to file a joint petition. So you have to keep that in mind. The fraud and consequences, there's a new policy of vetting all applications for fraud. So expect heightened scrutiny with applications with marriage-based, especially with parent for child, where you might be required, or they will suggest you do a DNA test, saying that you haven't proven the parent-child or child-parent relationship. Also, with the marriage, if you go in there without a lot of proof, you will face, additional scrutiny. You could get a potential denial or a notice of intent to deny. So it is important to file when you have the requisite proof. Now, turning to employment-based visas, obtaining an immigrant visa through employer sponsorship, there are 4 specific categories. The EB1s, extraordinary ability. And in this category, you are able to self-sponsor, but an employer can also sponsor. EB2, advanced degree, exceptional ability. Again, you can self-sponsor with an advanced degree and filing for the national interest waiver, but you can have an employer who sponsors you either under the advanced degree category or the exceptional ability. And then someone with a bachelor's or associate's degree, or no degree but 2 years experience, would qualify for the EB3. EB1s usually have no wait. EB2s have a shorter wait, maybe 18 months. EB3s have a longer wait. And EB4s may or may not, it just depends, because EB4s are special immigrants who have a weight, and religious-based, sometimes they have a weight. But EB4s, religious-based, are limited to members of religious orders. So it is not something that's widely available to anyone. Or it's also available to people who will be working for a church in various capacities. For example, a religious director would qualify for the EB4. Now, so if you are approved for one category in employment base, you can't just switch to another. So say, for example, you only have a bachelor's degree at the time that you're approved for an EB3, and you then get a master's. You can't switch and say you want to adjust based on EB2 because you were approved based on your bachelor's degree and not your master's. So, and you need to apply for the visa category on the day you apply. Meaning, if you're applying, say, as an advanced degree holder, you cannot, the employer cannot apply for you before you obtain your advanced degree. So that would limit that application to being filed after graduation. And again, eligibility requirements are different for each category. So the first preference, these are priority workers. They are persons with extraordinary ability in the sciences, arts, education, business, or athletic. Or it could be outstanding professors and researchers, or certain multinational managers and executives who have transferred from a company abroad to either a subsidiary or sister company here in the US. These three categories qualify as priority workers. The extraordinary ability is usually you have to meet 3 out of 10 requirements, and it's usually people who have risen to the top of their fields, have received awards that might be national or international, and have substantial experience. However, I have consulted with some students who qualify because of their past history. So don't automatically assume you don't qualify for this EB1 category because you're a recent graduate. Outstanding professors and researchers are another category that some PhD students may qualify for after they graduate if they've had 3 years of teaching experience. So again, it's important to do an individual analysis of the background before ruling yourself in or out. The second preference, EB2, is for members of the professions holding an advanced degree. I did mention that you are able to self-sponsor. It's also, this EB2 category also includes persons of exceptional ability. And PERM is required if there's an employer, but there's a shorter process for those with exceptional abilities. Again, with exceptional abilities, you need to meet 3 out of 6 requirements. And again, it's requirements that demonstrate you're in the top percentage of persons who hold these qualifications. So members, it looks at, memberships in associations that invite you to be a member, not that you just pay a membership fee and become a member. The third preference is for skilled workers, meaning persons without a degree. Professionals, these would be persons with a degree. Other workers, which could be someone with an associate, because the professionals are considered from bachelor level up. And then PERM is required. You go through the Department of Labor to do this. And the process is called PERM, but is also known as labor certification. And it's required for the EB2 and EB3 categories. The employer applies on the labor certification application, then must undertake advertising, recruit and interview anyone who applies in order to demonstrate that the employer has engaged in a meaningful recruitment process. And then the employer has to submit the results of the recruitment with the application. And if the Department of Labor does not feel the recruitment has yielded the results that it feels it could yield, they will order another recruitment that they will supervise. And then after approval of the labor certification, the employer can petition for the worker, which is on Form I-140. Now, no labor certification is required if the occupation is on Schedule A. These are occupations that the US government has determined there is a shortage in the US for. Therefore, physical therapists, professional nurses, that is someone who has a BSN or higher, would qualify in Group 1. And Group 2 are the immigrants of exceptional ability. College and university professors and immigrants of exceptional abilities in the performing arts. So it's immigrants of exceptional abilities in the sciences or arts, and then in the performing arts as well. So EB1A, extraordinary ability, EB1B, outstanding professors, EB1C, certain national, multinational executives, just to kind of recap the various categories under the employment-based. The benefits of going through the labor certification process is that if the labor certification has been pending for 365 days, or even if the I-140 has been pending for 365 days, and the person has an H-1B, they can renew beyond year 6 if an immigrant visa is not yet available. H-4 spouses can obtain work authorization if the principal H-1B spouse has a pending application for 365 days, or the employer petition has already been approved and they're just waiting for visa availability. That allows the spouse to be able to work as well. Now, a quick note about the H-1B category is that there's been an imposition of $100,000 application fee for employers filing H-1B petitions in the United States. So we will see in the upcoming H-1B season whether that has an effect on new H-1B applications or not. The government has been sued for this new astronomical fee, but again, that suit is still pending. And so we'll see starting in March whether employers are just not gravitating to the H-1B petition because of the high fee. So back to the labor certification, after approval of the labor certification, the employer files for the respective employee. And at this point, the focus is on the employer's ability to pay, whether it's a bona fide job opportunity. And in light of the policy change to vet more closely applications, you can expect that the U.S. immigration officer, when you go for your adjustment of status interview, will be focusing on whether this is a bona fide job opportunity, and during the approval process for the employer petition, we'll be focusing on whether the employer has the ability to pay, whether it's a bona fide position, whether they've hired someone in that position before. So this might pose a problem for maybe smaller employers, newer employers, startups who may not have filled these positions before. Again, these are challenges, but they do not mean these applications cannot be approved. They're still being approved. It just means that the documentation needs to thoroughly anticipate any potential challenges, and the applications need to be thorough. With the EB1, you're able to self-sponsor, which means you do not need an employer to sponsor you. You do not need a job offer. You just need to be seeking to enter the United States to continue to work in the area that you possess the extraordinary ability. You have to demonstrate that the entry will substantially benefit the US in the future. And then you meet 3 out of 10 criteria, which include prizes, memberships, publications, serving as a judge, um, significant contributions to the field, which would be conference presentations and authorships of scholarly articles. So examples would be, national institutions, and this can be in your home country as well as in the US. If you got awards for your doctoral dissertation, um, if you've been invited to become a member, and that membership is not available to the general public at large. So that would work as well. And significant contributions to the field, you can have people write, with whom you've collaborated, worked on different projects with, and have them talk about your contributions to the field. Those are usually the best types of letters. You can also self-sponsor under the EB2 category, and apply for a national interest waiver based on a proposed endeavor that has both substantial merit and national importance. You need to have an advanced degree, so unless you already have a master's, you have to wait. If you are basing it on a STEM PhD, you have to wait until you get the STEM PhD. STEM PhDs have a benefit in that they are presumed to be well positioned to advance their endeavor, and that their project has substantial merit, which are 2 of the 3 requirements. The third requirement is that it would be beneficial to the US to waive the requirement of a job offer and the labor certification process, which is designed to protect US workers. And so those are the 3 things that are required. And if you can demonstrate them, you would be able to, get granted. You do need to focus on your proposed endeavor because it needs to be solving a problem the US faces, and you need to be able to contribute to the solution to that problem. If you have an interested government agency, it's helpful because government agencies cannot petition for employees. So USCIS understands that if you have an interested government agency, this is of national importance to the US, and therefore you stand a good chance of being granted. It can be an entrepreneurial project because, as you know, you do not need an employer or a job offer. So it can be an entrepreneurial project, but again, it needs to be solving a problem. Your proposed endeavor, the entrepreneurial project, needs to be solving a problem that's of national importance to the United States. It cannot only benefit like the state you live in. I presented on the national interest waiver, and I've included in the PowerPoint slides, which Debbie will be sharing with you later today. I've included the link in case someone watching this or listening wants to, file for national interest waiver. So some tips to successfully navigate US immigration. For family-based, apply when you can prove you have a joint life together. If you don't make enough to meet the affidavit of support income requirements, find a joint sponsor, but make sure that sponsor would be the natural person to help, meaning your parents, your spouse's parents, etc. I've seen people find their employer and usually run into trouble with that because usually an employer would not be willing to support you beyond the employment relationship. So U.S. immigration law does allow you to pursue more than one pathway to a green card. So you can apply for an employer-sponsored and a self-sponsored green card at the same time, or an employer-sponsored and a family-sponsored green card. And you cannot apply for a self-sponsored, as I've said, until you meet all the requirements, until you meet the degree requirements. And if you initially work on OPT or on H-1B before the employer files for your green card, ensure that you time the green card application so you still have non-immigrant status and employment authorization during the green card process. Because if there's a wait for the green card, you won't be able to apply for an EAD while it's pending. So that's something to consider when you're considering timing. I get this question a lot during my monthly meetings. If you're an F1 student, you are able to have a pending petition for either by an employer or an immigrant visa petition, and you'll still be able to demonstrate the intent to depart, which means you'll still be able to qualify for the OPT. However, if you have filed to adjust your status, that would be a problem. And so you may want to get your OPT EAD before filing to adjust your status. But if you've only filed the I-140, or your employer has only filed the I-140, or your spouse has only filed the I-130 relative petition, but you have not filed to adjust status, then you would qualify for the OPT. This change, understand, is only USCIS, not the Department of State or the US Embassy. So if you've had an I-140 petition by an employer filed for you and you go back to the embassy to say get a visa stamp because you're now in your OPT phase of your F1, the embassy could say you have immigrant intent, and you might have an issue there. So adjustment of status policy change. Asylees adjusting their status will be interviewed with an agency focus on detecting fraud, misrepresentation, national security threats, and public safety. What does this mean? They will be trying to detect fraud. So meaning if in your asylum application, you said you had been arrested, but then on your adjustment of status application, you answered no to being arrested, that will be a problem. That will be considered misrepresentation. National security threats, if you're from any of the 6 countries that are considered to be enemies of the US, your application will take longer because they will be vetting you and going into your background to make sure you will not be a security threat. This includes nationals of Iraq. So, you know, that's something to consider. Also, when you're adjusting status, when they talk about public safety, this goes to drunk driving convictions, you know, any convictions that indicate violence would be problematic. Changes, there's now a focus on denaturalization, and people can be denaturalized if they misrepresented or concealed information during their application process, if they become a member of a subversive communist or anarchist organization within 5 years of being naturalized, if they receive citizenship because of a relationship with a parent or a spouse and that person loses their citizenship. So if your naturalized parent or spouse loses their citizenship, it can affect you. If you've been convicted of naturalization fraud, which is a criminal offense, if you acquire citizenship through military service and you are dishonorably discharged, people who join the military can qualify for citizenship immediately. They don't have to wait the usual 5 years or 3 years if they acquire that permanent resident status through a U.S. citizen that they remain with. And because of that, if you're dishonorably discharged, you can lose the citizenship. and then refusal under specified circumstances to testify before any congressional committee on subversive activities. Again, communist activities, or anarchists, so that's something to keep in mind, because it affects, it can affect you if the person who gives you your green card is denaturalized. And it can affect you if you're a naturalized citizen. Who's being targeted? Any naturalized citizen that the Department of Justice determines is important enough for them to pursue, or someone who they decide is a potential danger to national security. Naturalized citizens who have furthered any uh, unlawful enterprise or any criminal gangs, naturalized citizens who engage in various forms of financial fraud against the U.S. or U.S. corporations, naturalized citizens who acquire naturalization through government corruption, meaning the immigration officer is paid or bribed, or something like that, and naturalized citizens referred in connection with pending criminal charges. So you don't need to be convicted of furthering any unlawful enterprise or criminal gangs, of criminal gangs, not or, I'm sorry. So if you are just charged with furthering the unlawful enterprise of a criminal gang, you can be referred for denaturalization. So there's now a new policy change requiring all non-citizens to register. If you registered before you turn 14, you have to re-register after you turn 14. You have to do this registration within 30 days. And parents of kids 14 and under must register their kids. And upon registration, you're fingerprinted. Homeland Security will issue you the proof of registration, which you must carry with you, because if you're stopped and you don't have it, you will have a problem with ICE. Now, who do not need to register? Lawful permanent residents, anyone paroled in the U.S. for humanitarian reason, even if the parole has expired, anyone admitted and who is issued an I-94, so that would be students. And if you're present because you have an immigrant or non-immigrant visa, you do not need to register. And if you're in removal proceedings, if you've received an EAD card, if you've applied for permanent resident status, or been issued a border crossing card, you do not need to register. There are some other changes. They don't rise to USCIS policy level, but for example, it does actually. It doesn't change the law per se, but they are policy changes. Electronic payments of application fees, no more checks or money orders. This started last month, October 28th. Application fees have been increased and were increased by the Big Beautiful Bill, and these changes have gone into effect after July 31st. So it's important to check your fees on the USCIS website before filing any application. Also, USCIS has a Project Homecoming. They encourage self-deportation, and you can register and sign up for it on their website. The government has revoked temporary protected status for many nationals, including Venezuela, Haiti, Honduras, but there are more countries impacted. And they have said they're going to cancel those persons' Social Security numbers so that they're forced to leave, because without a Social Security number, it's pretty difficult to get a job. There's been travel bans imposed on numerous countries. I think there are about 36 countries affected, but there are exceptions. So people who have existing visas, lawful permanent residents, athletes traveling to the US for the 2026 World Cup Games or the 2028 LA Games. will, be able to get these visas. Because it's based on visa issuance, it will affect people getting visas at the embassies. But there may be an impact on persons applying for adjustment of status, because those adjustment of status leads to the issuance of an immigrant visa. The last time these travel bans were in effect, we saw some delay in issuing lawful permanent resident status or processing the application for some nationals of these countries, but it's a travel ban. So it affects you if you're traveling to the United States, and shouldn't affect you if you're already here in the United States. And also Afghans who are eligible, who helped the US when the US was in Afghanistan, are exempt from the travel ban. So they're still able to get their special immigrant visas at the embassy. There's been some important policy changes that affect F1 and J1 students. This is just a proposal, it's not yet final. So no, it could become final, but also understand it's not yet final. So they're proposing to change the admission period from duration of status, meaning duration of your studies, to 4 years maximum. They're eliminating the 30-day grace they're proposing to eliminate the 60-day grace to a 30-day grace to leave after you finish and conclude your studies. And it is unclear how students would access their 1-year OPT and 2-year additional STEM OPT if the rule becomes final, because then the F1 visa, which covers OPT and STEM OPT, would be limited to 4 years, which is less than the time it takes to get some PhDs, which take 5 years. F1s are required or will be required to complete their first academic year of a program of study at the school that issued their I-20, so they wouldn't be able to transfer schools after the first semester or after, a few weeks, like before the drop add change date. They would, if you are at a graduate level, meaning getting a master's or PhD, you're not allowed to change your program at any point during your program of study. So that would be a significant change where people are able to decide what they want to study. And then F1 students would be allowed to pursue a higher education level, would only be allowed to pursue a higher education level. So, for example, if you obtain a bachelor's, you could not go back to school for another bachelor's. You'd have to go for a master's. You could not go back for another associate's if you already earned a bachelor's. You would not be allowed, F1 students would not be allowed to change to the same I'm sorry, lower educational level. I'm repeating myself. I just said that. So that's those are some of the proposed changes. But again, like I said, it's not final. It's a proposed rule. The comment period ended at the end of September. Usually the government can take, sometimes 60 days to consider all the feedback and then propose its final rule after taking into consideration the feedback. All right, I'll take questions now. Or I'll go into the Q&A.
Yeah, Patricia, while you catch your breath,
Yes.
I want to thank you. That was such a comprehensive overview of, where students are, what they might be thinking about, and what changes they should be aware of. So can't thank you enough for your preparation for this workshop.
Always a pleasure. Now, where you said something about the Q&A, will you be
Yeah,
giving
so
it to
there's a
me?
Q&A. If you don't see it at the bottom of your Zoom screen, you could click on More, which is on the lower right-hand
Okay,
side,
yes, I see it.
and then you'll see Q&A. There are no questions yet. I
Okay.
think you've done such an excellent job of covering everything that nobody has any questions.
Or they're in shock
Or
and they're
they're in
just,
shock.
oh my goodness, what's
Yeah,
going to happen?
yeah. Well, we'll give it a minute. I want to
Oh, of
remind
course.
folks that if they would like a consultation with Attorney Minikon, they are available twice a month. The next two will be offered on December 10th and 17th. And it's easy to submit your request. You're just going to go to Grad Legal Aid's website, click on Immigration on the tab at the top. There's a lot of information about that service, including a link to submit a request form. So I imagine that we will get lots of questions that way in person.
Yeah.
All right, well, there are no questions.
Okay.
Jody, from ISSS, I just want to give you the opportunity to add in your 2 cents and give ISSS a plug or any reminders that you think are important.
Sure. Thank you. I will post in the chat where we are listing what we consider the most important immigration updates for our F1 and J1 students. This is under news statements and press releases for immigration news and updates. So as different changes are, we're learning of different changes, we are posting things here. So this is a good place to stop and see what things might pertain to you if you're an F1 or J1 student. And we are closely monitoring the D/S. Patricia talked a little bit about the D/S. This would have major implications once this if this gets passed. So we will certainly be holding webinars and outreach, lots of ways for students to engage should this pass, what that would mean for you. It will be a big change for the campus. So we are watching that closely.
Okay, excellent work. We appreciate you, Jody, and the good work your office does. I know things are complicated right now, but we appreciate your efforts to keep everyone informed. So thank you for being here today. And Patricia, again, thank you for being here. We value this important relationship. It helps us serve students with the highest quality. So
Yes.
this is our last workshop of the semester, so I will be back next semester with several new workshops, new topics, new speakers. We hope to see you then. Until then, have a good week. Happy Thanksgiving, and Legal Aid will still be here to help you even during winter break. So thanks and take care.
Okay. Bye.